Hello everyone, this is the second video on the family law topic. In the first video, we went through the issues of the parental responsibility of the biological parents of a child. We understood that the mother of the child has automatic parental responsibility over her child from the moment the child is born. However, the father can or cannot have automatic parental responsibility. He may acquire it in certain circumstances. You may recall we went through 6 different circumstances for an unmarried father to acquire parental responsibility. In this video, we will find out about those who are not the parents of the child but can have parental responsibilities. In other words, if a person is not a parent of the child, how he or she can acquire parental responsibility for a child. I will also discuss briefly when the parental responsibility ends, regardless if it belongs to the parents or the non-parents. In the second part, I will take you through the applications that require to file for the court order either with agreements or without agreements of the parents or the parties. Let's move to the parental responsibility for non-parents of a child. There are 4 scenarios where the non-parents of a child can acquire parental responsibilities. The first scenario is if the child is adopted. An adoption order will provide the adopter with parental responsibility. The second scenario is a person appointed as the child's guardian will acquire parental responsibility. However, this will affect after the death of the mother. The third circumstance is if a person who is not the parent or guardian of the child obtains a child arrangement order naming them as the person with whom the child shall live. The court must make a parental responsibility in favor of that person if they do not already have one. You can see it in Section 12, Subsection 2 of the Children Act 1989. If a person who is not a parent or guardian of the child obtains a child arrangement order in which they are named as a person with whom the child is to spend time, for example, have contact, the court may make a parental responsibility order in favor of that person. The court will consider whether it is appropriate to do so under Section 12 capital A of the Children Act 1989. So the fourth scenario is a step parent or civil partner as defined by the Civil Partnership Act 2004 may obtain parental responsibility in 2 ways in addition to those I explained earlier. Step parents can enter into a parental responsibility agreement with the parents who has parental responsibility already. All parties with parental responsibility will need to be a party to the agreement. If it is not possible to agree to this, the step parent or civil partner can apply to the court for a parental responsibility order under Section 4 capital A of the Children Act 1989. So now let's move if the application goes to the court what test for a father acquiring parental responsibility to be met. In the case law, in the case of Re H. Minors, Local Authority Parental Rights number 3, the Court of Appeal set out 3 steps test that should be applied in a father's application for parental responsibility. The court should consider number 1, the degree of commitment the father has shown towards the child. Number 2, the degree of attachment existing between the father and the child. And number 3, the father's reason for applying for the order, specifically whether they are child focused. So those are the three limbs of the test the court will apply on the application. So let's move to the when the parental responsibility ends. For parents who have automatic parental responsibility, for example, mothers and married fathers, parental responsibility will continue until the child is 18. The only way it will end before that point is if the child is adopted or if the parent dies. However, for an unmarried father, step-parent, or other persons who acquire parental responsibility in accordance with one of the method I explained in this video and in my first video on parental responsibility, you need to understand that the court has the power to terminate parental responsibility. Such an order will only be made in exceptional circumstances. For example, in the case of withdrawal of parental responsibility, which was decided in 2014, the court terminated the parental responsibility of an unmarried father who was registered on the birth certificate of a 5-year-old boy following the father's conviction for sexually abusing the mother's children from a previous relationship. So if a person who is not a parent acquires parental responsibility as a result of a child arrangements order being made in their favor, the parental responsibility order will last as long as the child arrangement orders ends. So this has been explained under section 12 subsection 2 and section 12 subsection 2 capital A of the Children Act 1989. If you find this information helpful, let's move on to the procedural or practical step to write an agreement if both unmarried partners reach an agreement over the parental responsibility of a child for the father. If it is not possible, what application do we need to file with the court? There are different forms to fill out for biological unmarried fathers and stepfathers. If you are an unmarried father, you need to fill in Form CPRA1 Parental Responsibility Agreement under Section 4(1)(b) of the Children Act 1989. You can see this form on the screen. This is a short and self-explanatory form. I will go through this briefly. The first page of the form only requires the parents to give the detail of the child, including his/her date of birth and when the child will reach 18 years. This also requires the parents to give their detail, including their names and address. You see, the form requires the detail of the witness as well. The form can be witnessed by a justice of the peace, justice's clerk, an assistant to a justice's clerk, an officer of the court authorized by the judge to administer oaths. You both need to take this form to a local family court office, and one of the officials I mentioned earlier can witness the form. Once the form is completed and witnessed, you need to post 2 copies of the form to the Central Family Court, First Avenue, 42 to 49, High Holborn, London, WC1V 6NP. Parental Responsibility Agreement for step parents require another form, which is CPRA2. This form is similar to the CPRA1 form we just went through. You can see the only difference is that you need to give detail of both parents having parental responsibility together with the detail of the step parent. Again, this form need to be attested by a Justice of Peace, Justice's Clerk, an Assistant to Justice's Clerk, an officer of the court authorized by the judge to administer oaths. You both or you all need to take this form to a local family court office, and one of the officials I just mentioned can witness the form. So let's move to the next steps to take if the parents do not reach an agreement and a court order is required. If the court order is required, you need to fill in the C1 application form and pay the court fee, which is at the moment probably £220. You may be qualified for fee remission or get legal aid. This issue is out of our topic today. So in relation to C1 application form, you need to fill in with all the relevant or applicable sections. Application for an order on form C1 can be completed by the guidance given on this form. You can see on the face of the form that if you are applying for one of the following private law orders, you must file a separate completed form which is called FM1 with this application. So FM form, as I explained, it is available on the gov.uk's website. You can also request the court to send you a copy of the application form. FM1 is the short name of the Family Mediation Information and Assessment Meeting form. You also call it MIAM, M-I-A-M. So as I explained, the law requires you must have attended a MIAM before making this application, unless the requirement to attend MIAM does not apply because the Children Act 1989 order you are applying for. It is very important to note that you can seek the exemption to go through MIAM if you are a victim of domestic violence, for example, or if the child is in the imminent risk. For example, if the child is being abducted or you have serious concerns about the well-being of the child and MIAM is not possible. So in that case, you need to explain the urgency to the court. If you claim you are a victim of domestic violence, you need to fill in with C1A form to file together with the C1 form. Let me summarize the process in easy 3 steps. If you are going to apply for parental responsibility order, the first step is attend MIAM. FM form advises you with the guidance on how to fill out the application form and what steps you need to take. The second step is once the MIAM process is completed and an agreement is not reached, C1 form needs to file with the court. The third step is if you are victim of domestic violence, you can explain the circumstances that you cannot go through MIAM. In this case, you need to file C1 and C1A application with the court. Please take this video for educational purpose only. If you need legal advice, please see your solicitor. I hope you find this video informative. I will record the next video on the Child Arrangement Order, which is also called Section 8 Order. Thank you for watching my video.